Can my employer threaten deportation? If I complain. Imagine this. You're working in a restaurant kitchen, on a construction site, in a warehouse, at a hotel, or doing cleaning work in someone's home. You notice something is wrong. Maybe you're not being paid all your hours. Maybe your supervisor is harassing workers. Maybe the conditions are unsafe and people are getting hurt. You think about speaking up because you know what's happening isn't right. And then the employer says something like, "If you complain, we'll call immigration." For many immigrant workers in the United States, documented, undocumented, or waiting for paperwork, this fear is real. Some employers use immigration status as a weapon to silence workers and avoid responsibility. The question is, can they legally do that? The answer, under U.S. law, is no. Threatening deportation because a worker speaks up is illegal retaliation. In this video, we'll explain what the law actually says and why your rights do not disappear because of your immigration status. Your rights do not depend on immigration status. One of the most important truths many workers don't realize is that labor rights in the United States apply to all workers, regardless of immigration status. Whether someone has a green card, a temporary visa, a work permit, DACA, temporary protected status, overstayed a visa, or has no papers at all, the law still protects their right to be paid fairly, to work in safe conditions, and to speak up without retaliation. This is because the law protects the work, not just the worker's paperwork. The Fair Labor Standards Act, FLSA, requires every worker to be paid at least the federal minimum wage and overtime when working more than 40 hours a week. The Occupational Safety and Health Act, OSHA, gives every worker the right to a workplace free from serious hazards. Title VII of the Civil Rights Act prohibits harassment and discrimination. The Americans with Disabilities Act, ADA, protects workers with disabilities, and the National Labor Relations Act, NLRA, protects the right to discuss wages, organize, and take collective action. None of these laws require proof of citizenship. None of these laws disappear because someone is undocumented. Threatening deportation is illegal retaliation. When an employer says, "We will call immigration if you report us," that is not just intimidation. It is illegal retaliation. Retaliation means punishing someone for asserting their legal rights. And retaliation is illegal under federal laws, including the Immigration and Nationality Act, INA, the FLSA, OSHA, and the NLRA. Even if the employer never makes the call, the threat itself violates the law. The government recognizes that for immigrant workers, especially those without permanent legal status, the threat of deportation can be as powerful as physical force. For this reason, agencies treat this type of retaliation very seriously. For example, imagine a group of restaurant workers who ask to be paid for all their hours. The manager responds, "Keep quiet, or I'll call immigration." Even if no one is ever reported, the workers have already experienced retaliation. The employer has broken the law. Why the law protects undocumented workers. 2. Some workers believe that because they are undocumented, reporting violations will lead to being deported. But labor enforcement agencies do not enforce immigration law. Their job is to investigate employers, not workers. If employers could simply exploit undocumented workers without consequences, wages for all workers, including citizens, would collapse. Unsafe work would spread. Abuse would grow. So the law protects undocumented workers to protect the entire workforce. This means undocumented workers can file complaints, participate in investigations, testify in hearings, and receive back pay, even if their immigration status is uncertain. How employers use fear. Employers who threaten deportation often use a pattern of intimidation. They may hold workers' passports or IDs. They may say things like, "You don't want government trouble," or "People like you should be grateful." They may spread rumors that reporting labor violations will result in arrest. They may assign harder tasks or reduce hours when workers speak up. These tactics are illegal. Taking or holding someone's identification is considered coercion and can even be treated as labor trafficking under federal law. Reducing hours, moving someone to a worse position, or firing them because they complained is also retaliation. And retaliation is illegal whether a worker has papers or not. How reporting actually works. If a worker chooses to report a violation, they can do so confidentially. Agencies like the Wage and Hour Division of the Department of Labor, OSHA, the Equal Employment Opportunity Commission, EEOC, and the National Labor Relations Board, NLRB, do not ask about immigration status when taking a complaint. Their role is to enforce workplace law. And here's something many workers don't know. When retaliation happens, workers may be eligible for immigration protections such as temporary protection from deportation, work authorization during investigations, U visas in cases involving threats, coercion, or exploitation, T visas in cases involving forced labor or trafficking. That means reporting abuse can actually increase safety, not decrease it. Examples from real cases. In California, farm workers exposed to pesticides reported unsafe conditions. The employer threatened to call immigration. OSHA intervened, fined the employer, and protected the workers. In New York, a bakery threatened deportation when workers discussed forming a union. The NLRB ordered reinstatement, back pay, and penalties. In Florida, construction workers who were denied wages were threatened with deportation for asking questions. The Department of Labor recovered unpaid wages and additional damages. In each case, the workers were protected. The employers were held responsible. No one was deported for speaking up. What workers can do safely. If a worker is threatened, the first step is to document what happened. Write down what was said, who said it, and when. Save text messages or voicemail if they exist. Keep pay stubs, timesheets, and schedules. Talk to coworkers. Many cases are stronger together. Seek help from worker centers, immigrant advocacy organizations, legal aid, or unions. Many provide confidential support in multiple languages. A worker does not need to show immigration papers to report retaliation. The human side threats of deportation do not just control workers inside the workplace, they follow them home. They create fear in the grocery store, at the bus stop, during family time. Employers who use these threats know that workers care about their families, their futures, and their safety. The law exists to prevent precisely this kind of abuse. Everyone deserves dignity. Everyone deserves safety. Everyone deserves fair pay. And the law agrees. So, can your employer threaten deportation if you complain? No. Threatening to call immigration to silence workers is illegal retaliation under federal labor law. Workers, including undocumented workers, are protected under the FLSA, OSHA, Title VII, ADA, NLRA, and the INA. Your right to fair wages and safe conditions does not disappear because of your immigration status. The bottom line, your employer is not the government. They do not have the power they want you to fear. If this video helped clarify your rights, share it with coworkers. Knowledge breaks fear, and no one should face intimidation alone.